Welcome to Aspen Leading Edge. I'm Patty Roberts from St. Mary's University School of Law, and I have three guests with me today. Ann Lipton, Professor of Law and Lawrence W. DeMuth Chair at the University of Colorado Boulder. I also have Donald Langevoort from Georgetown Law, where he is the Thomas Aquinas Reynolds Professor of Law. And rounding out the group is Patrick Corrigan, Professor of Law from the University of Notre Dame Law School. And the three of them, along with founding co-author James Cox, who unfortunately is not able to join us because of international travel, are the authors of the 11th edition of Securities Regulation Cases and Materials. So welcome to all of you, and I'd love for you to share with our listeners how Securities Regulation Cases and Materials first came about and how we got to the 11th edition.
I'll take that one because I was one of the people there. Jim Cox had the idea there was not a casebook out there on the market that did what was necessary to train future lawyers in the field. And he asked a couple of co-authors, including me, what would we think of as the ideal book? And why isn't the ideal book out there already? He was very anxious to have a high-end book that would not be afraid to go deeply into securities regulation, because securities regulation is a deep subject and you have to get that right, and you can't dumb down the study of such a complex, important field. He also believed that the best way to teach was by problem solving, and we became the first book to have large numbers of problems. And to this day, I think we all have our favorite problems that have been tried and true for the last 20 years.
Thank you, Don. So Ann and Patrick, when did you join this journey in securities regulation?
I joined it with the 9th edition, and I do not remember what year that was. It was a few years ago. So I came on the book in the 9th edition. I was invited on by Jim and Don. I was a practicing securities litigator and was relatively new to teaching the subject, but I was using this book. And they invited me to come on, starting out with chapters that were most relevant to what I've been practicing, which is like the anti-fraud stuff. And then my responsibilities have expanded a bit since then, and that's where we are.
For my part, Jim, Ann, and Don reached out a couple of years ago, a year or two ago, and invited me to join on for this new 11th edition. And I feel very privileged to do so. It's a remarkable book, and to be able to be invited to join in on that project is fantastic. Before I was a law professor, I did a little practice on the general corporate side, M&A, capital markets, bank regulatory, and a lot of some of my research has focused on, especially on initial public offerings. And so I'm thrilled to join on for this new edition.
Well, that's terrific. It must be a popular book if you're on the 11th edition, and congratulations. I know that's going to be published in November 2025. So you mentioned problem solving, and for a book that has been through so many iterations, it's very interesting that it started being very heavy in problem solving, since that hasn't been how we have taught in legal education for all that many years. So can you describe a little bit about what those problems that are included for students to work through? What are they like? What would the students expect?
I'll take that one. And the reason I'll take it is because one of the things I'd like to explain to my students straight up is that the thing about SecReg is, unlike the vast majority of cases that you learn, the classes that you take in law school, it's not really common law based. It's not like read a case. SecReg, I say it's like tax in that way. It's a code class. It's based on the statute and it's based on the rules. And there's actually comparatively little case law. Of course, they're always fooled because the what is a security that opens the book, that's all case law. And then they get into the rules. Oh no, because students work on little cases. So the problems are there. I think they're very useful because you don't have cases. You don't have a case where you can say, here's a hypo, here's a particular thing that happened, and here's how the court decided it. So the only way to create those hypothetical situations for students to work through is through our hypothetical problems that are the kind that if you were an attorney, you might approach the SEC and ask for a no action letter if you didn't understand how the rule operated. So they're just like hypothetical, client wants to do this, company does this. Is that compliant with the rules, not compliant with the rules? How can you make it compliant with the rules? That kind of thing.
Well, that sounds like terrific material for the students to learn this topic, but also sounds like it will lend itself well to kind of practice for the next gen bar kinds of experiences that students will have in problem solving. But let's talk about the 11th edition in particular. So why the 11th edition? What are the things that we can see in this edition that are new to securities regulation cases and materials?
Well, it's easy to start out with an answer. Securities regulation is extraordinarily dynamic compared to even other regulatory subjects. A case could be made for a new edition every year, and it wouldn't be wasted time or wasted effort. What happens for this edition is simultaneously with all the regular updating, we had such things as cryptocurrency taking over the debate about how much of securities regulation should or should not be invoked in formulating Bitcoin's future or stablecoin's future or anything like that. And that turns out to be very partisan. And so there's an element of politics that's gone into the 11th edition that wasn't as necessary in prior ones. But we have to capture the trajectory of securities regulation, and we're holding our fingers crossed that we've got it right. And next month will prove us needing another 12th edition in about 6 months.
Well, yes, I hope for you as well that doesn't happen. Patrick?
Can I add, Don, do you remember around the year the first edition was published?
It's around 1990.
Around 1990. Okay, so the other element I would add is if you compare the capital markets in 1990 to the capital markets today, they look quite different. So a number of factors I think we emphasize in the book are institutionalization, so the rise of large asset managers, pools of money, changing nature of hedge funds and other asset managers, private equity. But then there's also the technology, just the technology that the capital markets run on, that goes on in the background. And that's another layer to the dynamism that Don was talking about that has changed as these editions have changed.
Yeah, and I'll just throw in that, I mean, one of the things that happened after the 10th edition came out, I mean, it was almost very shortly after it came out, a whole bunch of rules were rewritten, and we had to immediately, and Jim took a lot of labor and more on that, had to immediately write a supplement that sort of incorporated all this new stuff. And now that's, formally in the book, although as Don points out, given how many changes have been proposed and are, being talked about, we may have a supplement very quickly with that changes it all again.
So if you could share for our listeners, what are some of those changes? What are some of those significant changes in the field that are now memorialized in the 11th edition?
It's hard to answer that question because so many of these changes are still happening. It's not this has happened. This is happening, and who knows where this is taking off to go. The new administration, the Trump administration, has a more radical attitude toward deregulation than even ordinary Republicans were over the last decades. They're prepared to make things and break things in the field of securities regulation. So to the extent that trajectory holds for a couple of years, the deregulation that's going to need to be reflected in our casebook will look somewhat different from if this all slows down and things return something toward what we were expecting a year or 2 years ago.
Yeah, I mean, I'll just say that one of the things that ended up getting rewritten and changed just after, I guess, our last publication had to do with essentially making it a lot easier to sell securities without formally registering it. There have always been paths to sell securities without formal registration, which is basically a lot of disclosure. But they changed a lot of the rules around to make it a lot easier to sell without registration that we had to immediately create the supplement for, and now that's in the book. However, proposals are now out there for even more, loosening those rules even more to make it even easier to sell securities without registration. But how, exactly how that's going to play out, we have no idea. So that's the kind of thing that's constantly changing.
And Anne circulated an email a month or so ago when word came out that mandatory arbitration might substitute for securities litigation. Which she said would lead to a shorter book.
It'll be a much shorter book. We have a very thick chapter on securities litigation. It becomes securities litigation history.
Well, that can remain historical, right? You can put that chapter as a history chapter. So let's talk about Bitcoin and cryptocurrencies. I think that's something everybody's hearing a little bit about, and you indicate that there's very partisan views, but where do you come down on it in the book in the field of securities regulation? What do you as securities regulation experts think should be the way that cryptocurrencies are handled in SecReg?
I wrote the chapter on crypto, the chapter that has crypto embedded in it. And, this is an illustration of work in progress. Please don't try to predict what will be out there or even how. I think we need a slowing down of the process. Deregulators like to talk about sandboxes in which entrepreneurs can play as they try to establish a niche or maybe even a takeover of the field of currency and all the other things that the blockchain promises. I am skeptical of that. If you play and make unwise choices, these aren't going to be easy to fix. They're global finance. So I wrote, where are we in 2005, the middle of 2005, in terms of the litigation that has gone on, what has been done to that litigation, which is the SEC has backed off enforcement of many things that they had committed to before. So my note was going to try to be caution, because I haven't myself figured out what the optimal solution is. But rushing forward heedlessly is probably not what we're going for.
I'll say one of the interesting things on that question is that, states have tended to define what is a security similarly to the federal government. But if what we see is a pattern of the SEC simply not enforcing securities laws against crypto as a policy matter then we may very well see state regulators step into that space much more. And they already have kind of taken the lead on that. Now, obviously, if the federal law changes, like as in Congress passes a law that defines what is a security, it could preempt state law and make that process stop. But until that happens, one of the things that's interesting in this space is seeing, like we've already seen a few state regulators start to say, well, I don't care if this is a security under federal law, it's a security under state law, and I'm going to enforce my state law against it.
I'll just add on this topic. The first layer, there's your classic questions. Is it a security? Another interesting area that has me interested in is what are solicitations in this space? And so you have new technology, which is raising interpretive issues in terms of how do we apply the classic securities laws questions to these new institutional structures. So decentralized exchanges, for example. Is there anyone to whom you can go after for Section 12A1 liability? Because if you're trading anonymously and there's no one soliciting, these raise just interpretive questions. And then there's the broader question of the policy process and the legislative process, which is something I don't think we touch on that much in the book, though I share Don's sense of I prefer a little bit of slower movement here.
Patrick, I wonder if you can just define what solicitation means in the SecReg space. I'm thinking it means like somebody writing to me and saying, here, would you buy crypto, or are you interested in buying crypto? But I just want to clarify it for our listeners who are not maybe experts in SecReg like me.
Great point.
Not
That's exactly right. That's the easy case. An easy case of solicitation is, do you want to buy this security? Here, I have a security to sell. Do you want to buy it? And that's important because liability under Section 12A1 for violations of Section 5, you can only go after a defendant who is a seller, and a seller is one who solicits for their own benefit or for the issuer's benefit. So someone who says, I think you should buy this security because it's a good deal and it's just a gratuitous recommendation, they're not expecting anything in return, that's a person where it will be difficult to establish that they're a seller and therefore to be able to name that person as a defendant for Section 12A1 liability. So the question is, are there people who are soliciting for the benefit of themselves? I get some kind of a commission or some kind of benefit through this solicitation. So sales we're worried about promoters, sales effort, the people who are pushing these unregistered securities? Or am I soliciting for the benefit of the company that's issuing these securities? And, as you see new forms of technology, these decentralized exchanges, you see new forms of communications on chatboard or social media or things like this. I think it just raises interpretive issues about how do we, the old image of someone in a boiler room calling, making phone calls is sort of the archetype, but how does that apply in the new landscape, I think is still an evolving question.
And a one-off question on that subject has to do with what happens when you have celebrities or former politicians becoming those solicitors, which is a reordering of how securities used to be sold. But with social media, no surprise that people who do well in front of a camera may provide keys to more successful solicitation.
I saw a social media post the other day that said, while you're making dinner, you can mine Bitcoin. Learn more. I was like, what in the world? Like, there's so many layers to that I just can't comprehend.
Mm-hmm.
But it's certainly the Wild West as far as cryptocurrencies go. So maybe that new edition will be coming sooner than we think. So for the 11th edition, who do you recommend this book for as far as faculty go? And I know you've made it intentionally modular so that there's some flexibility for faculty who want to teach using the book. So can you share a little bit about that?
I'll start, but Don, as one of the founding members, probably actually is a better handle. But I mean, I think one of the things about this book is compared to some of the others is it is more technical. I mean, this is a technical area and the book is more technical. And we've heard from some people who use it that that's what they like, because the point is for students, if this is an area that you're going to practice in, and it's a class for people who think they might practice in, it's not like a broad survey class, then you need to understand not just the specific technicalities, which do change, but how technical it is and how to deal with technical material. So it doesn't shy away. I mean, like, that's a constant judgment call that we're having to make. Okay, when is this just getting ridiculous? Versus, but there is a rule. The rule has subparts. You have to comply with the rule as written, and making sure that students not just understand this particular rule, which will change by the time they graduate law school, but how to read the rule and how to understand the rule.
Yeah, let me just talk a little bit about the founding assumptions that led to the book we now have. This is meant for a course in securities regulation, and law schools vary on how many of their students want to take a technical, challenging course like this. Enrollments, I suspect, from school to school vary incredibly long. And we want it to be available to everybody. That's the modularity in the book. The beginning of the chapter is more general. You can assign that to get to a certain level of just what's this all about. And the layers, as the chapters go on, become more and more technical and more subject to being omitted if you are teaching the kind of class that makes you want to spend time elsewhere. We are trying to make sure that professors can also use the book as preparation material. Those who teach securities regulation run a substantial range in terms of background and experience with the subject, and we want to help out in that itself. I call securities regulation corporations too, in the sense that if you want to be a corporate lawyer, you can't stop halfway through the progression of your learning. You don't finish corporations until you finish securities regulation.
I think that's an excellent point. And I have been hearing from some of my faculty in this field that the big law firms are concerned because not as many students are taking this course, or as you would say, part two of corporations, right? So they come in less prepared. And so I think that's something that faculty should be considering when they're developing their curriculum. So another thing that you've added is a chapter on distinctions between international and domestic transactions under securities law, and where it sounds like here in the US, it's volatile, it's unpredictable a little bit right now, a little rocky. What is it like for securities regulations globally? Is there more consistency in SecReg globally than there is currently in our own country?
Well, this chapter doesn't really try to assess international securities law, although there are some chapters in the book, they're not my chapters, that talk a little bit about some global considerations. But for that chapter, the issue is like, given the international capital markets, how do you tell when a security was traded in the US such that it is subject to US law? And it's another area where cryptocurrency is a really big issue. In one case, the Second Circuit said, well, we're going to call Binance like US in part because they claim they don't have any home anywhere, and that can't possibly be right. So fine, they're here. Okay, problem solved.
Crazy times. Okay, well, anything else before we move to our final question that you'd like to add about Securities Regulation Cases and Materials 11th edition?
No, I think we've captured it pretty well.
But one thing we didn't talk about, maybe one last thing I'll ask you about, is the teacher's manual. What will faculty find in the teacher's manual?
We've had a teacher's manual since the beginning, not surprisingly, to a case book that is dedicated to the problem-solving approach. The TM is filled with answers to the questions that we pose. And we want to suggest to the faculty teaching this material, not that we're going to make you give an answer. I disagree with some of the answers in the teacher's manual that my co-authors have put forward, but we can get the person started by a background script, which allows some degree of confidence going forward that this isn't just my answer to the question. It's what should be the answer to the question.
Sometimes we put a little bit more context, like in addition, a lot of it is answers to the problems. A lot of it is a little more context to the stuff in the book. This is how the law has changed a little bit. You may want to discuss with your students this other issue. Sometimes if I think putting something in the book itself would just be way too dense. It's just like, in this case said this, in this case said that. I'll try to capture that idea in the teacher's manual so that the teacher has that background if they want to have that discussion, that kind of thing.
Well, again, congratulations on the 11th edition of Securities Regulation Cases and Materials. It's kind of exciting to think that the students who are learning from this book and learning in this field are likely going to be the ones who are creating the long-lasting policies and law surrounding the cryptocurrency market. So stay tuned, right? Well, before we conclude, I wanted to ask all of you the final question I ask all my guests, and that is, what are your predictions for the future of legal education in the coming decade? Don, you want to start?
Sure. Do I have answers I'm confident in? No.
That's the nature of predictions. That's fine.
We certainly, artificial intelligence, the future of artificial intelligence will give us a partial answer to that question. And I thought about, what artificial intelligence is necessary, should get worked into the 11th edition. And I came away deciding that we have a few mentions to it in the broker-dealer and investment advisor space, but we're far away from making confident predictions there. It's going to reflect the legal profession. And to the extent we have, as a result of this, less demand for associates and more demand for very successful partners in law firms that do this kind of incredibly challenging work, that's going to have spillover effects on the administration of law schools as well as what goes on teaching in the classroom.
Anne, anything to add?
Well, I'm a very traditional sort of teacher, so I'm not sure what kind of things are going to change. But the only thing that I'll just add is that artificial intelligence is obviously going to be a big issue. It's going to be looking at documents and drafting documents, doing first drafts of documents, things like that. But I think right now there's obviously changes at the federal level that have to do with student loans, things like that. So I imagine law schools are going to have to adjust to essentially the cost of a legal education and figure out how to make it as affordable as possible given those kinds of changes, because it's possible that students will have more trouble getting financing and grants and so forth.
I wonder if in the coming decade, some people will be paying in cryptocurrencies for their tuition. Patrick?
So, well, just on what Ann said, I think that the student loan issue is going to be a big, important one. My hot take on the future of legal education, maybe it's cold take, is it's not going to change that much. I'm not an AI skeptic per se, but I'm more of a wake me up when you have something to show me. I haven't seen, I think right now AI is a little bit of a time saver. It can save time and maybe on analyzing contracts or due diligence or doc review, maybe it helps. I'm not sure, but I think you still, in fact, when I talk to lawyers, what they're all saying is we need to be hiring more. They're hiring more, and that could be the business cycle too, but I don't see any sign of AI yet replacing really good good, competent legal assistance. And so I think teaching students to think like lawyers, legal analysis, and, we have a way to do it. I don't know if it's the best way, but we've been doing it for a long time. We have our core curriculum. We teach people to think like lawyers. And I think that's going to continue. But like Don, who knows? I don't have a lot of confidence.
Well, thank you so much, Don Langevoort, Ann Lipton, and Patrick Corrigan for joining us today. And I hope that James Cox is staying safe and having fun in Chile. Have a great rest of the semester.
Thank you for having us.
Thank you for listening to today's episode. If you'd like to listen to additional thought leaders in legal education, you can find additional episodes of Aspen Leading Edge on YouTube and your favorite podcast channels.